Introductions to Private International Law. Overview of Private International Law. Meaning of foreign law. The name of the subject. Introductions to Private International Law. Meaning of foreign law. The name, definitions, nature, and scope of private international law. Space and time in private international law. The choice of law, impact of European conventions on human rights, and the general scope of private international law. Private international law is a part of English law and is relevant when a court encounters a claim involving a foreign element. It serves purposes like establishing jurisdictions, determining applicable law, and recognizing foreign judgments. Its necessity arises from the existence of multiple legal systems worldwide. Private international law, a segment of English law. It becomes relevant when a court found a claim involving a foreign element. There are three primary purposes. First is jurisdictions. Establishes the conditions under which a court can entertain a claim. Applicable law determines the specific municipal law system to ascertain the party's right. And recognitions and enforcement specifies when a foreign judgment can be recognized and enforced in England. The necessity of private international law arises from the existence of multiple distinct legal systems worldwide, each regulating various legal relations differently. Courts must often consider foreign laws to avoid injustice and ensure rational adjudications. It is a very crucial part of English legal systems and many other countries who also have English legal system background, such as Malaysia and Commonwealth. It comes into play whenever a court is faced with a claim that contains a foreign element. It is to determine the conditions under which the court has the authority to hear such a claim, to identify the specific system of domestic law that should govern the rights of the parties involved, to specify the circumstances in which a foreign judgment can be recognized as decisive in the dispute, and the conditions under which the rights granted by a foreign judgment can be enforced in England. Private international law delineates the geographical scope of legal rules. For instance, an English court may apply French intestacy laws to distribute the estate of a person domiciled in France but with assets in England. The temporal aspect involves determining which law applies at different times, such as the domicile at the time of marriage or at the time of the testator's death. Private international law is pervasive and can arise in a lot of legal proceedings. It involves jurisdiction of the English court, recognition and enforcement, and the choice of law. Foreign law refers to any legal system outside the court's jurisdictions, including laws from other parts of the UK, Commonwealth countries, or EU member states. Private international law varies globally with no universal system. For example, English law relies on domicile for personal status, while many European countries use nationality. The conflicts can be mitigated through unification of internal laws, international conventions standardizing law, such as the Warsaw Conventions for Air Transport, unification of private international law, harmonizing choice of law rules to ensure consistent outcomes regardless of the trial locations. The term private international law is widely used, though conflict of laws is also common. Both terms are understood by legal professionals and accurately describe the subject. A foreign element can manifest in numerous forms in legal disputes. One of the parties might be a foreign national or domicile abroad. The issue might involve property or assets located in a foreign country. A contract might have been made in one country but performed in another. In all such cases, private international law rules come into play to ensure that the appropriate legal system is applied to resolve the matter. For example, if an Englishman marries abroad, the validity of that marriage according to English law might depend on the laws of the country where the marriage occurred. Historically, the idea of comity of nations, referring to mutual respect and courtesy between nations, was often cited to justify the applications of foreign laws. However, modern legal analysis views this concept differently. Today, the recognition of foreign law is not merely an act of courtesy, but a necessary aspect of delivering justice in a globally interconnected legal system. Space refers to the geographical scope over which a legal rule applies. For instance, while English law might dictate certain contract terms, PIL, or private international law determines the extent of its applications in cases involving foreign parties or transactions. Time addresses whether the laws applicable to a case are those in effect at the time of the transactions or the time of the legal proceedings. This consideration is essential, particularly when laws change over time in the relevant jurisdictions. The jurisdictional rules of English courts vary depending on the type of legal action. For instance, for most civil claims, a court gains jurisdiction if the defendant is served with a claim form while in England or Wales. In divorce cases, mere presence in the country might not be sufficient to grant jurisdictions. Different rules apply to cases involving European Union member states, which are governed by EU regulations that ensure uniformity in jurisdictional matters across member states. Foreign judgments are generally recognized in English courts if the foreign court had proper jurisdictions according to PIL principles. This recognition is crucial in cases where a judgment needs to be enforced in England, especially if the defendant's assets are primarily located in England. Once a court determines it has jurisdictions over a case with the foreign elements, it must then decide which legal system's law should apply. This determination, known as the choice of law, is a central aspect of PIL. For example, in cases involving contracts or torts committed abroad, the applicable law might not be English law, but the law of the country where the contract was formed or the tort occurred. One of the challenges of private international law is that it seeks to address the diversity of laws across countries and jurisdictions. There are two approaches to minimize conflicts. The first is unifications of internal laws. International conventions such as the Warsaw Conventions for Air Travel or the Hague Conference on Private International Law. These two aim to unify internal legal systems on specific issues. Such unifications reduce the possibility of conflicting laws. The second one is unifications of private international law. Efforts like those by the European Union aim to harmonize private international law rules across member states, ensuring that cases with foreign elements are treated consistently regardless of where they are tried. For the purposes of private international law, the expressions foreign system of law refers to any distinctive legal system prevailing in a territory other than that in which the court is functioning. This includes not only the law of a state under a foreign political sovereignty, but also the law prevailing in subdivisions of the political state of which the forum is a part, such as the law of Scotland, the Channel Islands, Northern Ireland, or a member country of the Commonwealth or European Union. There are at least two reasons why the recognitions of foreign law may be necessary in a case with a foreign element. The first is avoiding injustice. The invariable applications of the law of the forum, which is the local law of the place where the court is situated, would often lead to gross injustice. For example, if a person engaged in English litigations is required to prove that they are the lawful widow of a man who died abroad, the marriage ceremony may have been regular according to the law of the place where it was performed, but not satisfy the formal requirements of English law. Applying English law in such a case would be a travesty of justice. The second is carrying out the court's policy. If the court is to entertain actions in respect of foreign claims, it must take into account the relevant foreign law or laws. For instance, if a claimant seeks damages for breach of a contract made and to be performed in France, the court must consider French law to determine the nature and extent of the relief to which the claimant is entitled, as well as whether they are entitled to any relief at all. Disregarding French law might reverse the legal obligations of the parties as fixed by the law to which their transactions was originally subjected. In the past, English judges and legal scholars have frequently used the term comity of nations. This is to justify the applications of foreign law. However, this term has been criticized as being grating to the ear when it proceeds from a court of justice. Analysis of the term reveals that it has been used in a meaningless or misleading way. The word comity is incompatible with the judicial function, as it is a matter for sovereigns, not for judges required to decide a case according to the rights of the parties. If comity means courtesy, it is inconsistent with the readiness of English courts to apply enemy law during wartime. If it means that no foreign law is applicable in England except with the permissions of the sovereign, it is merely a truism. The fact is that the applications of foreign law implies no act of courtesy or sacrifice of sovereignty. It simply derives from a desire to do justice. Private international law is not a separate branch of law in the same case as the law of contract or tort. It is a pervasive aspect of the legal system which can arise unexpectedly in any court and in the midst of any legal process. Nevertheless, private international law is a distinct unit within the English legal system, as it is always concerned with one or more of three questions. One of those is jurisdictions of the English court. The basic rule at common law is that the English court has no jurisdictions to entertain an actions in personam against a person, unless the defendant has been personally served with a claim from in England or Wales. However, there are certain circumstances in which the court is empowered by statute to assume jurisdictions over absent defendants. And certain types of action, such as petitions for divorce, where the mere presence of the defendant in the country does not render the court jurisdictionally competent. The second is recognitions and enforcement of foreign judgments. If there has been litigation abroad, but the defendant has most of their assets in England, It will be important to determine whether English law will recognize or permit the enforcement of the foreign judgment, provided that the foreign court had jurisdictions to adjudicate the case. According to English private international law, the English court will generally recognize the foreign judgment as if it were one of its own and enforce it accordingly. And finally, the choice of law. If the English court decides that it has jurisdictions, it must then consider the choice of law, which is the system of law, English or foreign, should govern the case. The action before the English court may concern a contract made or a tort committed abroad, or the validity of a will made by a person who died domiciled abroad. English private international law directs which legal system shall apply to the case, indicating the particular legal system by reference to which a solution to the dispute must be reached. Private international law is not the same in all countries. There is no single system that can claim universal recognitions, though there has been a significant movement towards the harmonizations of private international law rules between groups of countries. This presentation concerns solely with the English rules, the rules that guide an English court whenever it is faced with a case that contains some foreign element. The rules of private international law can vary significantly between different legal systems. For example, in England, the personal status of a party depends on the law of their domicile, while in France, Italy, Spain, and most other continental European countries, it depends on the law of their nationality. Similarly, the principles applied by various legal systems to divorce jurisdictions may conflict, such that the same two persons are deemed married in one jurisdiction but unmarried in another. There are two main ways in which the lack of unanimity among the various systems of private international law may be ameliorated. The first is unifications of internal laws. One approach is to secure, through international conventions, the unifications of the internal laws of various countries on as many legal topics as possible. Examples of this include the Warsaw Conventions of 1929, as amended on the international carriage of persons or goods by aircraft, and the Berne Conventions of 1886, as amended on the protections of the rights of authors over their literary and artistic works. The second is unifications of the law itself, the private international law. This method is to unify the rules of private international law so that a case containing a foreign element results in the same decisions, regardless of the country in which it is tried. Significant progress has been made in this regard through the work of the Hague Conference on Private International Law, which has drafted numerous conventions aimed at reducing the number of topics on which the rules for choice of law in different countries conflict. The English court's jurisdiction is generally based on personal service within England or Wales. However, statutes may extend jurisdictions to absent defendants, especially in foreign cases. Some of the cases include Re Bonacina, which address contractual validity under foreign law, Amin Rashid Shipping Corporation versus Kuwait Insurance Co., discussing Comity of Nations, Spilida Maritime Corporations versus Cansulex Limited, establishing this case established the principles for forum non-convenience. Foreign judgments are recognized if the foreign court had proper jurisdictions. Some of the key statutes include Civil Jurisdictions and Judgments Act 1982, which implement the Brussels Brussels Conventions. And in the case of Kuwait Airways Corporations versus Iraqi Airways Co., examining the interactions of public and private international law. The choice of law determines which legal system applies to which case. English law often differs to foreign laws for issues like contract validity and property distributions. Relevant statutes include Contracts Applicable Law Act 1990, which govern contractual obligations, and the Wills Act 1963, which address the validity of wills under foreign law. The European Union, the EU, has significantly influenced private international law through treaties and regulations such as Brazil's One regulations, which govern jurisdiction and enforcement of judgments, Rome 1 and 2 regulations, addressing contractual and non-contractual obligations. The Human Rights Act 1998 incorporates the European Conventions on Human Rights into United Kingdom law affecting private international law, such as Article 6, right to a fair trial, and Article 8, right to respect for private and family life. The Human Rights Act 1998 incorporates the European Conventions on Human Rights. Under Article 6, it ensures fair trial rights in jurisdictional and enforcement matters. In Article 6, it has been invoked in cases involving jurisdictional disputes and the recognitions of foreign judgments, ensuring that parties receive a fair hearing. While Article 8, which is a right to respect for private and family life, it is to balance private and family life rights in cross-border disputes. Article 8 has been considered in cases involving family law and child abductions, ensuring that decisions respect individuals' private and family life. The incorporations of these European Conventions on Human Rights into UK law through Human Rights Act 1998 has introduced new dimensions to private international law. Courts now must ensure their decisions, including those involving foreign elements, are compatible with fundamental human rights, such as the right to a fair trial, Article 6, and the right to respect for private and family life under Article 8. A modern feature of private international law is the Europeanizations of the subject, which refers to the assimilations of member states' private international law rules and the creations of a European area of freedom, security, and justice. This development is based on the Treaty of Amsterdam, which made judicial cooperations in civil matters a matter of European Union law rather than just intergovernmental cooperations. The European Union has been a major force in the creations of uniform law within the community and the unifications of private international law among EU member states. This has resulted in the unifications of private international law among this has resulted in the adoptions of various EU directives, regulations, and proposed regulations containing private international law measures, such as the Brazil's One regulations on jurisdictions and the recognitions and enforcement of judgments in civil and commercial matters, and Rome 1 and Rome 2 regulations on the law applicable to contractual and non-contractual obligations, respectively. Private international law varies globally with no universal system. English law relies on domicile for personal status, while many European countries use nationality. In order to avoid conflicts, it can be mitigated through unifications of internal laws, where international conventions standardizing laws, such as the Warsaw Conventions for Air Transport, as well as unifications of private international law, it harmonizing choice of law rules to ensure consistent outcomes regardless of the trial locations.